Hi dear students, in today's class we will do the revision of section A, chapter 4, the Union Judiciary, the Supreme Court. You must remember that chapter 5, the High Courts, and chapter 6, the subordinate courts. It won't be for your board exams. Only chapter 4, the Union Judiciary, the Supreme Court will be there for your board exam. Now you take chapter 4, page number 40. In page number 40 itself, some features of Indian judicial system is given. India has got a single integrated judiciary system. From this chapter, you have to mainly focus on appointment of the judges, the qualification of judges, the composition, the powers and functions of Supreme Court, and the enforcement of fundamental rights. First, we will see about the composition of the Supreme Court. You take page number 40, composition and organization of the Supreme Court. The one point it is given, according to the Act of 2008, the Supreme Court consists of the Chief Justice of India and not more than 30 other judges. Chief Justice plus not more than 30 other judges. That is the composition of the Supreme Court. And in the same paragraph itself we can notice about the appointment of the judges. Each judge of the Supreme Court is appointed by the President after consultation with the judge of the Supreme Court and the High Courts as the President may feel necessary. When the President appoints judge other than the Chief Justice, he always consults the Chief Justice of India. The Chief Justice in turn must consult the four senior-most judges of the Supreme Court before making any recommendation. So the appointment it is given, and down to that the qualification of the Supreme Court judge it is given. Now we will see the qualification. First of all, the person must be a citizen of India. The second point, he must have been a judge for at least 5 years in a High Court of India, or he should have been an advocate of High Court for at least 10 years, or fourth one, he must be in the opinion of the President a distinguished jurist. So the qualification also we have seen. Now you may take page number 43. There we will see about the jurisdiction of the Supreme Court. First of all, you should know what is jurisdiction. Jurisdiction means the power that a court of law exercises to carry out judgment, to interpret laws and to settle disputes. So that is the meaning of jurisdiction, and there are 4 types of jurisdiction: original jurisdiction, appellate jurisdiction, revisory jurisdiction and advisory jurisdiction. What is original jurisdiction? In original jurisdiction, the Supreme Court hears the case in the first instance itself, and in the appellate jurisdiction, the court can change the decision or reduce the sentence passed by the lower court. And there are 3 types of appellate jurisdiction: constitutional cases, civil cases and criminal cases. And in advisory jurisdiction, the Supreme Court can give some advice to the President if President seek advice from Supreme Court. In revisory jurisdiction, the Supreme Court has got the power to review any judgment or order declared by the Supreme Court. Now we will see about the functions or the powers of the Supreme Court. The first one is Court of Record. Supreme Court is known as the Court of Record. The reason is that its judgments are recorded for evidence and testimony for the future use, and if there is any violation, then the person will be punished. And the next power or the function of the Supreme Court, it is power of judicial review. What is judicial review? The Supreme Court has the power for judicial review or examine any law passed by the legislature. We had seen that legislature is the law-making body of government, and even the Supreme Court can review the laws made by the legislature or the law-making body, and the scope of judicial review also is given. You have to go through that one. And now we will come to the most important point, that is enforcement of the fundamental rights. And under this title, you have to study 5 important points. And first of all, you should have an idea about what is writ. Writ is a command or a official document containing a particular person or an official to act or not to act in a particular way. And there are 5 types of writs. The first one it is writ of habeas corpus, then writ of mandamus, third one writ of prohibition, fourth one writ of certiorari, and fifth one writ of quo warranto. All the writs you have to study and the definition of all the writs, and these are all the things that you have to study from this chapter, and you can please go through the text and the revision notes I sent you. Thank you. Have a nice day.